All right, good morning. This is our lecture on Chapter 1. And the way I've designed this class is for you to predominantly be reading the text. It's critically important that you read each chapter. That's why we've pretty much only done one chapter per week. Some of this is going to get more in depth as we go further. But for this first week, if you've read the chapter, you're going to be fine with your discussion posting. Um, this lecture is designed to really just cover the highlights of the chapter, not to go fully in depth into it. I don't have that much time, nor do I think anybody's going to pay attention online that long. But a combination of both of them will set you up for success. And so, with that, let's dive right into chapter 1. If I get my screen set up the way that it's supposed to. So, we're going to talk about a couple of different things with this introductory chapter. We're going to talk about the development of crime. We're going to talk about how the criminal justice system was created, what that system looks like today, the formal and informal processes of the criminal justice system, what criminal justice reform looks like, and we're going to talk about ethics. Many people believe today that crime exists at a rate that is worse than it ever has been. And quite frankly, that's just not true. Crime is not a new development. It has existed in the United States since the United States was formed as a country, just in different forms, different mediums. But violent crime has always been a problem within the United States, and even in worldwide. Person and property crimes have changed over the years as technology has emerged, as we've moved into an industrial age and the technological age. How we commit crime has changed, but crime has always existed. The reason we believe today that it's worse than it ever has been before is our exposure to it. 24-hour news media systems, instant access online to be alerted anytime something bad has happened to anywhere in the world. It becomes a constant dialogue. The reality is that in terms of person crimes, those numbers have actually gone down over time. But because we're exposed more to it, we've become more sensitive to it. Business crime, or what we call white-collar crime today, actually didn't show its teeth until during the Civil War, when businesses were caught selling goods to either the North or to the South, when there were laws that prevented them from doing so. The Great Depression also influenced criminal activity, mostly based on need, because of the critically low employment numbers, people in poverty, people essentially on the breadlines looking to secure whatever they could for themselves and for their family. Crime, in a sense, has always served as a vent for anger, and it has always served as a person's decision to protect their own interests, whether those were moral decisions or not. Criminal justice, as we understand it, has morphed over time into the monster that it is today. Formalized policing agencies did not exist until 1829, when the London Metropolitan Police was first created. Was first created by Sir Robert Peel, and we'll talk more about Peel and his principles of policing later. It's had a lasting impact on the entire system, and is someone that people like me look to when we talk about things like public consent or the consent to be governed, etc. His methodology and thought process through that process has held on and resonated worldwide since the early 1800s. In the United States, we really didn't begin to talk about formalizing law enforcement until the commission of the Chicago Crime Commission. They were the first formal body to come together to talk about law enforcement processes and what their focuses should be. And that was privately funded. The government had nothing to do with that. The first time the government spent any money on formalizing our justice systems was in 1931, when Herbert Hoover created the Wickersham Commission. And even then, the impact at that point only existed at the federal level. At the local level, law enforcement agencies were still considered to be a blue-collar, labor-intensive job that didn't require much in the way of preparation or education. If you showed up with a desire to serve or a basic sense of common sense, that's essentially how you were hired. And our laws were structured in a way to protect the citizens from some of that. Kansas is a good example of that. Until 1972, sheriffs had no educational requirements. but they were limited to two-year terms before someone else stepped in. In 1967, we began to see that change with President Johnson's Crime Commission. Really began the process of formalizing not only law enforcement, but our criminal justice system as a whole. So we were talking about the courts at that point. We're talking about our correction systems at that point, and really began to build out what is the professional system that we see today. So what's criminal justice look like today? Right out of our text, the criminal justice system is our formal instrument for social control. Without the criminal justice system in place today, we don't have anything but anarchy that exists. Law enforcement's job is to preserve the peace and protect the public. The court's job is to evaluate the event that's occurred, ensure that constitutional liberties were protected, and then deal with offenders appropriately. And then the correction system is built completely to carry out the court's order and how those sentences are carried out. Every single component, all three of those components are impacted by all three branches of government. This is something that always makes me chuckle a little bit when they say, well, law enforcement belongs to the executive branch, or no, law enforcement really belongs to the judicial branch, but it's actually the legislature that gets to tell cops what it is that they do. The fact is, we don't belong in a single branch of government. We as law enforcement may be governed predominantly through the executive branch, but it's the legislative branch that tells us what laws exist and how we're supposed to enforce them, and they provide the funding for it. It's the executive branch that creates those policies and guidelines through leadership and through other directives that point us in the right direction of how to implement what the legislature has told us to do. And it's the court's job to balance every decision that we make against the Constitution and against existing case law to make sure that we've done it in a manner that protects the rights of our citizens. Essentially, today, we see formal and informal justice processes that exist. And the formal process is enormous. It carries out, it's intensive. There are a ton of different steps here. So as you can see, that as I've put on the screen, law enforcement's responsible for the initial contact. Something's gone wrong and we need intervention. Then it's law enforcement's job to investigate what has occurred, who carried it out, etc., and make an arrest if it's necessary, and then hold them in custody prior to that. It's the job of our prosecutors to determine how to charge someone. It's the job of the courts at that point to conduct a preliminary hearing at felony level cases to ensure that a crime actually did occur and that there's probable cause to believe that the person arrested actually committed that crime. We'll talk more in the future about what probable cause actually means or doesn't mean. Then a defendant is brought before the court. They're told what it is that they've been charged with, and the judge has to make a decision balanced between the weight of the crime that's been accused and the general safety of the public based on bail. Plea bargaining is a piece of the formal process. Sometimes trial, which doesn't happen as often as people think it does, but we'll talk about more of that later as well. Finally, sentencing, and of course, everyone has the absolute right to an appeal regardless of the type of case. Those are all the responsibilities of the court. Our correction system is responsible for carrying out those sentences or helping an offender with treatment if that's what's been ordered. They're also responsible to make sure that those people are released at the appropriate time and then monitor them through post-release. Those are things like probation, parole. Post-release supervision is the term that we use in Kansas on a regular basis. The informal side disregards that entire model, doesn't get anywhere near to it. And every branch except for corrections typically has a way to intervene informally without going through all of those other steps. The first thing that probably comes to mind with most of us is the police have broad discretion in many cases of how they can and cannot act. Let's use drug cases for an example. Police on a regular basis encounter someone who's in possession of some substance, and the desire is to remove all of that off the streets as best as they possibly can. So it's not uncommon to find someone who's simply in possession of marijuana or some other drug and ask them to cooperate, provide information about who they bought it from, where they bought it at, etc., to allow law enforcement to move up the ladder. If the information they've provided proves to be accurate, proves to be correct, their charges are never even sent to the county attorney and no one's ever arrested. Sometimes prosecutors will look at an offense and decide they don't want to put that person through the formal court system, and they use what's called diversions. We see this often with speeding tickets, MIP cases, things like that, where they may ask them to take a class on why alcohol is bad for kids, or to take a class on why accessing tobacco at 16 is harmful and potentially destructive. Ask them to pay a fine that doesn't go through the court system, and then no criminal record ever exists that they were brought through the court system. One of the biggest criticisms of the informal process is that it heavily relies on discretion. We heavily depend upon those officers who make agreements with offenders to use their judgment in that they've selected the right offender for their goals, and that offender is likely not to offend again. And it's the same with county attorneys or district attorneys in the prosecuting side of the house. It's up to them completely whether they provide that diversion or not, and we're relying on their judgment about whether that's the appropriate course of action to take. That's never without criticism. Those are all based upon opinions and gut feelings, and nobody's gut feeling is ever going to be the same as the person who's beside you. Criminal justice reform is heavily discussed in Chapter 1, but it is something that has been ongoing for a long time. We've heard the term as a buzzword since pretty much 2014 with the Ferguson effect, and then amplified through COVID with the George Floyd effect. Reform has become more formalized, but it has been an ongoing discussion since the criminal justice process was ever formalized to begin with. There are several different avenues related to reform that have become predominant or have big impacts, and it all comes from the perspective of the advocates for reform in the first place. Advocates for the crime control perspective look at the law enforcement and the criminal justice function as a deterrent force, meaning I take action here on one person who committed a crime, others see it, and they're deterred from doing the same thing because they don't want the same punishment that this person got. Rehabilitation, especially in substance abuse cases, is a big push here lately. In other words, that it's better to treat the illness of addiction than it is to punish that. And they believe in large part that criminals are a victim of society or victims of their own environment, meaning someone who's grown up in a house that's prevalent for substance abuse is more likely than someone else to become addicted to the same or similar substances as their parents, siblings, or anyone that they've been associated with. Normalizing substance abuse as a culture has been an issue that expounds on substance abuse. Here in Northwest Kansas, where I live, alcohol use is extremely prevalent. It's a cultural thing. It is not abnormal to see parents give a teenage son or daughter in their own home a beer to drink if they choose to. They've normalized the consumption of alcohol, at least in this part of the state. That contributes to some of those factors of it's our job then to rehabilitate these folks instead of simply to punish them. The due process perspective is something that we see from a lot of libertarians or libertarian-minded people, in that everyone, regardless of the size of the offense, deserves the full weight of all the constitutional liberties that are applied there. And to a certain extent, the court always ensures that that's the case. It's usually the defendant's choice whether they move forward or not. But some of these reformers believe that regardless of the decision the defendant makes, each of those liberties needs to be measured and applied before they're simply set aside. The non-intervention perspective is from the perspective of those folks that once you've been convicted of a crime, a stigma or a black cloud now exists over your head that the public sees. And they believe that there's more harm created by the public knowing that you've been convicted of a crime than you actually dealing with the consequences of the crime, which might make you more likely to reoffend just because of the thought process of, well, the world already thinks I'm a criminal. I might as well just go ahead and become a criminal. The equal justice perspective is a touchier one. It relates to a lot of factors, but one of the biggest one is the socioeconomic factors. People who live in impoverished conditions or low income conditions are provided court-appointed counsel through the court system. That's a constitutional right that exists. But they're given that because they can't afford to hire their own counsel. The argument is that court-appointed defense counsel does not work as hard and is not as deliberate in their methods as someone that we've hired, which creates an inequality. In other words, we may see someone who's received a court appointed attorney who's been charged with, say, DUI. And this defense counsel who's been appointed works to negotiate the case away so that they don't have to take it to trial, but this person is still punished. Someone who's comes from a better background or can afford to pay for counsel may see their case go all the way through trial, find a mistake that law enforcement made, and walk away completely acquitted, even if they both committed the same offense. That's the inequality measurement that they're discussing there. Equality justice folks also see discretion as a negative and seek to reduce just how often law enforcement and prosecutors are given the ability to make decisions about where to move a case. Restorative justice has been a relatively new one that has come up within the last 15 years, and it discusses kind of a combination of the stigmas that exist against offenders and working on eliminating the stigmas and working to reintegrate these offenders back into society. Some of us, like me, believe that that can be appropriate in some cases, but there are some crimes that are heinous enough that that simply isn't applicable, and we've got to protect society. They also believe that crime is a product of the community, not of a decision from the individual. Finally, ethics. Ethics is a significant problem for the criminal justice process, for the entire system, because usually when there is public discourse about a decision that's made, it's because an officer, a prosecutor, or a judge has made a decision that just is completely off the rails, completely different than what society expects or what the practical norms are. And when that occurs, the outcry is not small. Usually we see this in terms of protests. Usually we see this in terms of sweeping legislative changes across the state, or we see it within case law. From the cops' perspective, one of the statements that we have always made is that dumb cops or bad cops make bad case law that impacts all of us. Body cameras is an example of this. When the Ferguson investigation was completed and it was determined that that officer acted appropriately, the public outcry was gone. It had already gone so far that nothing those investigators could show was ever going to dispel that down. That brought on the influx of body-worn cameras to be able to release that information faster, to be able to show this is what we told you happened. Now we're showing you what happened, and it makes it tougher to argue against. But that's just one example of that. Okay, this week we are working through Chapter 1, and your discussion board, let me get it brought up here, bear with me. Your discussion board is on ethics. Ethics has been a facet for criminal justice since we've formalized this profession. As technology changes and as processes changes, it also challenges agencies to ensure that every new process they take is an ethical one. So what I'm asking you to do is read the entire chapter, focus on the section related to ethics, and then within 150 words, provide an answer to the question that's posted there for your discussion board. I'm not asking for replies from your classmates yet. I may have to change that. We'll see what the bosses tell me to do. Remember, this is my first class and I'm just learning it. And I'm not asking you for this one to look completely outside the text. Again, we'll focus almost the entire class on our textbook. So that can be predominantly there. Use the writing standard that you're used to. I've been informed that's MLA. I'm an APA guy, so I will have to be checking back on what the MLA standards are, but make sure that your citations are appropriate. This is college level work, and the quicker you get into the habit of appropriately citing things, the easier the rest of your college process will be. So thank you for your time and your attention, and I will see you guys next week with Chapter 2.